Our May meeting minutes. Any corrections, concerns?
I'm fine.
I have none.
I have none.
A motion to approve?
I'll make said motion.
I'll second.
All in favor?
Aye.
Aye, motion carries. Thank you. What do we got going on with plans? I saw we had something coming up in July.
Yeah, Gunst. I have sent an email to them asking for an extension, but I didn't receive it yet, so in the interim, I'd say amend denial if an extension isn't received. I'll hope to have it before the board meeting. And just for confusion, remember there was a lot line change for Gunst. This is a subdivision where they're breaking off a house for the one daughter. Breaking off a lot. For
Did
one.
we see that plan?
No,
Okay.
I don't think we saw the
I mean,
subdivision version.
did you send out a review letter?
Yeah, I sent out a review. It was reviewed. They just haven't come to the meeting yet.
And the same with Snyder's Green Top?
We've seen a plan for that, at least one.
or
Yeah.
Green Top? We didn't see it here, though. I think we saw it via email.
Maybe via sketch.
Yeah, there's Snyder Green Top also, just, CYA. I'll talk to him also. He thought he was gonna be on this agenda, but he didn't get his information in under the new policy.
Make a motion to recommend declining both properties if we don't get an extension.
Second.
All in favor?
Aye.
Aye. Opposed? Motion carries. Thank you. All right. So moving on. We're doing old business. I have no old business. Anyone have old business?
No.
Oh,
Steve, you got anything?
No.
All right. Going to new business. So first thing we have is an amendment to the data center ordinance. Everybody get a chance to look it over?
Yes.
yes.
Okay, so basically they adopted the first version that we looked at. Because they wanted to get everything on record as fast as possible in case somebody came in with a plan. This is an amendment to that first adopted ordinance. And I'm positive they're gonna want us to, well, they're gonna want to adopt this second round next week. I don't know what comments you guys might have on it, but John, do you have anything?
Yes.
Okay.
I wrote this out ahead of time, not knowing what size crowd we were going to get, so it sounds like I'm speaking to the spectrum or something here, but I'm not. So I'll start by saying that I recognize the level of energy that surrounds this topic and the passion in the community to protect our environment. Also, while my comments here are critical of this ordinance, none of it is meant in any way to be a criticism of the township officials and staff who worked long hours to craft this ordinance. Also to the many residents who submitted comments to the township in an effort to make this ordinance a success for the township. I read every one of the comments, and let me assure you, we're all working towards the same goal. I also recognize that my comments are likely not to be popular with the attendees tonight. However, I strongly believe we need to get this right. To begin, I need to address a dangerous misconception. There seems to be a false sense of security that if the township puts a protective rule into an ordinance, it automatically becomes enforceable law. That is not how Pennsylvania land use laws work. What has been drafted in both Ordinance 256 and 257 is a bit of a political wish list that tells people exactly what they want to hear. But unfortunately, it may be built on a foundation of legal quicksand. We must do everything in our legal power to defend our township according to the established rules of the Commonwealth of Pennsylvania. We can't pile things on because it feels good to do so. The authority given to our township was established long ago and has been the legal framework for municipal law. Under the doctrine commonly referred to as Dillon's Rule, municipalities like West Rock Hill Township are treated as political subdivisions created by the Commonwealth. They do not possess inherent independent sovereignty. First adopted by the Pennsylvania Supreme Court in the 1870 landmark case, Philadelphia versus Fox, Dillon's Rule serves as the ultimate legal restriction against local township overreach. According to the official Pennsylvania Local Government Commission, a township can only exercise authority granted in express written words by the state legislature. That is, specific powers listed in the Pennsylvania Municipal Planning Code or the Second-Class Citizen Township Code. We cannot simply invent unique zoning powers out of thin air because our residents are anxious. We cannot point to an exact section of the state statute that explicitly authorizes a clause. That clause is legally dead on arrival. The Pennsylvania Supreme Court has consistently held if there is any fair, reasonable, or substantive doubt concerning whether a township has the power to pass a specific regulation, the court must resolve that doubt against the municipality and strike the law down. From what I have read and studied, rather than correcting the highly questionable utility clauses that were passed in Ordinance 256, this new draft doubles down on them and adds entirely new, potentially fatal violations. If we pass this potentially flawed ordinance, we are handing a data center developer a golden ticket to sue us under a substantive validity challenge under the Municipal Planning Code. When a court strikes down an ordinance, a county judge can grant definitive relief, giving the developer a direct permit to build their facility with zero local input on noise or setbacks beyond the basic restrictions previously established for the PI district. If we want a shield that actually protects our township, it must be ironclad and legally enforceable. Passing this draft does not protect our residents. It potentially exposes our taxpayers to massive liability. I will cite 6 instances where this draft fails the test of Dillon's rule, escalating errors of Ordinance 256. Number 1, escalation of de facto exclusionary zoning. The baseline in Ordinance 256 required a 25-acre minimum site. There are few vacant parcels in the PI district that could meet this standard. The escalation in the new draft raises the minimum area to 35 acres. While the Municipal Planning Code allows us to set reasonable lot sizes, it does not give us the power to use mathematical tricks to ban a lawful use. There are currently 0 undeveloped single lots in our PI district that meet the 35-acre requirement. The Pennsylvania Supreme Court ruled in Zurich versus Zoning Hearing Board that an ordinance is unconstitutionally exclusionary if it permits a use on paper, but applies a physical restriction that makes the practical development an impossibility. Ordinance 256 left a narrow path. The new draft creates a total legal blackout. Number 2, escalation of utility preemption. The baseline in Ordinance 256 requires a utility capacity study to evaluate future growth needs. The escalation in the new draft requires a developer to determine the impacts on municipal electric rates and legally prove that they've completely eliminated any negative rate impacts. The state legislature has never granted townships the power to regulate electric utility systems or protect consumer rates. Under the Pennsylvania Public Utility Code, that authority is granted exclusively to the State Public Utility Commission. In Duquesne Light versus Upper St. Clair Township, the PA Supreme Court explicitly ruled that local zoning cannot override state PUC jurisdiction to condition or restrict public utility operation or rates. Number 3, escalation of off-site infrastructure coercion. The baseline in 256 required infrastructure upgrades under relevant utility codes. The escalation in the new draft frames regional electric system expansion as an absolute blank check condition prerequisite to zoning approval at the applicant's own expense. Rather than granting this power, the state municipal code explicitly denies it, stating, no municipality shall have the power to require as condition for approval the payment of any off-site mitigation or improvements. Under impact fee challenge versus New Britain Township, we cannot coerce a single developer into funding off-site regional utility capacity expansions. Number 4, the solar mandate. Both versions mandate 100% solar coverages on roofs, mandatory solar parking canopies, and a 40% structural vertical wall integration using specific building materials. The violation under the Municipal Planning Code, while the Municipal Planning Code allows us to encourage renewable energy, it does not grant express statutory authority to mandate specific architectural features or force a business to construct a passive power plant on its walls. Furthermore, state building codes are strictly preempted by the Pennsylvania Uniform Construction Code, which explicitly states that a municipality may not adopt an ordinance which alters, amends, or exceeds state building requirements. Number 5, unconstitutional delegation of legislative authority. The ordinance text, both versions state that solar mandates must be applied to the maximum extent technically feasible as determined by the township engineer. The legal violation in power ruling is that the municipal planning code requires zoning ordinances to contain clear, uniform, and objective standards. In Eclat Microwave Incorporated versus the Commonwealth of Pennsylvania, courts confirmed that a governing body cannot delegate vague, arbitrary decision-making authority to a single administrative employee or engineer without strict statutory boundaries. And number 6, the unauthorized public safety impact fees. Ordinance 256 did not require economic impact inventories. The new draft adds an explicit application hurdle. The new ordinance mandates that an applicant submit an estimate costs expected to be incurred by the township related to emergency preparedness, administrative cost, police protection, and fire protection. The violation, the MPC strictly prohibits a township from levying impact fees or extracting financial concessions for general administrative costs, police departments, or fire protection. Core public safety budgets must be funded exclusively through general taxation and not leveraged through zoning applications. I know this was a lot of bad news that people didn't want to hear, but I freely admit that I am not by any means a legal expert. In fact, the commission is composed of dedicated residents, not utility tariff attorneys or industrial architects. We lack the technical expertise to properly evaluate the physical and structural safety hazards of these sweeping rules. For example, data center HVAC cooling loops require massive unobstructed airflow to prevent catastrophic fire hazards. Mandating that they be heavily canopy covered solar panels could present a potential engineering impossibility. I don't know, but I want to find out now before this ordinance is approved, not afterwards. I know that the Board of Supervisors feels a sense of urgency for getting this updated ordinance enacted or concerns there is a potential applicant waiting just around the corner. However, given the choice between getting something on the books quickly with weaknesses could see it blown away like a house of cards by a legal challenge versus getting an ordinance passed that has the benefits of a full intensive independent review that provides us with a solid defense against legal challenges, I move that we take the solid path for a review. If a legal review supports the ordinance, then we are better for having waited. If the legal review finds flaws, it is far better to know that now before it is too late, because the potential consequences of failure are greater than any of us want to see. The old adage says that no good deed goes unpunished. I have a fear that unless we perform the proper due diligence now, we are at risk of getting something that we don't want in return. Therefore, I formally move that the Planning Commission recommend to the Board of Supervisors to halt proceedings. We must commission an independent third-party subject matter expert review by a licensed utility attorney and an independent systems engineer. Let's hit the pause button and adhere to the strict boundaries of the Municipal Planning Code and the Public Utility Commission regulations in order to protect our taxpayers from potential costly losing lawsuit and ensure that we only enact ordinances that are 100% legal, bulletproof, and defensible under Pennsylvania law. Thank you.
Well, thank you, John.
Did you happen to talk to our attorney?
Because of what we said before, I didn't want to get accused of sunshine law violations.
Well, you
so.
can talk to him personally and get clarification. His thoughts on your concerns. It's a lot of information.
I think we need an independent review. Even the general information email that Greg sent out yesterday was an open letter by somebody.
Right.
And one of the recommendations was get the experts in. And my concern is doubled because not only if we are treading outside of where we should be, we did that in the first version. We doubled down on it in the second version. if this ever gets before a judge, I don't know that we'll get a third shot at it.
What about Article 3, the severability clause at the end? Basically says if any part's not right or illegal, invalid, that the rest
Still valid.
still holds.
I think the problem is we've got 6 pieces that are 5 or 6 that are questionable. And as you start looking at that, I think it's human nature to think, well, there's 6 things that are that wrong. It's all wrong.
I actually cut this down. I had more.
Steve, did you work with the attorney on this?
I did not.
You did not. You have any input?
No. I mean, I was going to mention the same severability clause. That's in all ordinances for that, stated purpose is to not have an entire ordinance thrown out if there's something found wrong. I don't know where the tipping point is where a judge would say there's too many things wrong. We're going to throw the whole thing out, but that's supposed to be the fail safe to not have an entire ordinance thrown out.
They can pick it apart, find things that they find called illegal, but not trash the whole ordinance.
Mhm.
All right. Any other comments?
I had a couple, under section 2, water and wastewater. I thought it would be helpful if we required the applicant to provide a map showing the path of the water coming to the site and the path of the sewer going out. Especially if they decide they need a force main to get the sewage out. Because that's gonna potentially sewer other parts of the township. We may not intend to have sewer there.
Right.
The other thing,
Well, most of the industrial district has sewer except for Cat Hill Road.
I still think it's worthwhile seeing the path that they're proposing
I
to
agree with that.
come from.
Would that come from them or would that come from the water and sewer utility?
What I've seen in planning modules in the past is a request for it to be included so that the people reviewing it can see where it's coming from. Typically, you do end up having to go to the water and sewer utilities to determine what that path is. But at least then when the planning module comes into us, we can see what that path is. And like I said, I don't think it's anything more than the state requires, so I don't think that would be an issue. Also in that section H, verification signed by the applicant and or person authorized on the applicant's behalf that acknowledges the information in the water and sewer feasibility study is true to the best of the person's knowledge, information, belief. I think somewhere above that, it requires a hydrologist, a PE. I think we just require that statement be signed and sealed by a PG or PE.
What is a PG?
Professional geologist.
Thank you.
I just think that gives a little more, someone's putting their license on the line at that point. It's not just someone signing off saying, oh yeah, it's all good. Likewise, when we talk about the power feasibility study, I think a PE should sign off on that. Under height, this is something coming back to something Steve had talked about before, and maybe it should be a general modification of the zoning. But we talk about 35 feet from the ground. What defines the ground? Like, is it at a given point? Is it an average? Is it the highest point, the lowest point?
Yeah, then we see an example of that recently where the ground was sloped and what was 35 feet on one side was a much,
60 on the other.
52 on one side and 100 on the other. It's not 100, but it's
much more than
it's
50.
much more.
Yes.
I mean, typically it was from the front facade. Am I correct?
Your ordinance has it from the front facade.
And we were,
Could be much higher on the sides and the rear.
right,
Some ordinances have an average,
right. And
some have just a maximum
that's something that you had brought up in a previous.
That's it, yeah, more general clarification that should be in the ordinance.
Like I said, I think that one has much broader reach than just this.
Yep.
The other thing I would suggest is if we think more work needs to be done, I would recommend we propose a citizens advisory committee be formed. Much like we did for Adelphia and the compressor station, it would not contain a quorum of any township regulatory body. So in other words, there could be no more than two of us on a committee like that, one supervisor. But I think it'd also be helpful to get input from the citizenry on what they think about it. And I think there could be a lot of exploration done that would really drive this in a direction that might be much more beneficial overall for the township. I think that group should provide a written document, if not a draft ordinance, to the township, just saying, here's what we've researched, here's what we found. But I think it provides a lot more freedom for exploration of different ideas and different inputs. I'd also suggest that it wouldn't hurt to have an attorney on it.
I mean, I know there's been discussion about putting together a citizen advisory committee. I think there's going to be discussed at next week's supervisors meeting about how to proceed. And I'm pretty sure that they're counting on that group to come up with draft number 3 or amendment number 2 to the data center ordinance. So it is something that's evolving.
Right.
Yeah.
I just think.
Whether or not it's going to be like you're saying, if it's going to be a citizens group that's not
Or an
part of the-
official township committee,
Yeah.
but I just personally feel, based on what we did with the Adelphia site, that I think a citizens committee provides a lot more flexibility than you get with an official township committee.
flexibility as into input or how the input is.
Input,
Rather than-
exploration of everything. I mean, we had a bunch of meetings with Adelphia that, admittedly didn't go anywhere, but they were unofficial meetings, so they didn't need to be publicly advertised, all that kind of stuff.
Yeah, and I think that would be at the discretion of the supervisor, whether they want it to
Right,
be
where they want it to be
Strictly
that way, but
a township commission or committee, or as an advisor, a citizens advisory group that doesn't have to answer to the township.
right.
But I'll go back on what my point was here. Without some legal representation skilled in this area, there has to be boundaries. I mean, it was my research into all this clearly showed me that there are certain boundaries that you got to stay within. And we've taken a lot of input from us and the population, and we've got a lot of great ideas. But as I said, not every great idea meets the letter of the law.
Mhm.
And you got to somewhere along the line, somebody's going to make a decision whether we're going to, roll the dice and hope nobody challenges it. We'll take the safe route and make sure what we've got is solid, that somebody's willing to put their seal and signature on it, that, yep, this stands a legal review. It's good to go.
I agree completely.
Yeah, I would tend to agree with John. You get a lot of feelings and emotions in groups that are not constrained by some type of, hierarchy, and and I think the legal aspect of it is important to avoid the problems that we had with the Adelphia stuff and wasting township money on lawsuits and
Yeah, that was a
spending
bit of
money
a-
that we don't have.
Well, yeah, for sure, but that was a bit of a different animal.
Understood. Understood. But why create a potential situation that would give it the same outcome? If
Right.
it's not defensible, Revert
Yeah,
back
I
to
mean,
the
well, we have
original
to-
PI standards.
We have to put a little bit of confidence in the attorney that we have hired that drafted this.
That was my
And-
question, right? So the solicitor drafted, so what level of oversight is there applied at that point, right?
Exactly.
I would imagine some level, right? Otherwise, why put ink to paper if, they don't think it's going to go anywhere?
Right. That's,
I guess my thought is though, that a municipal attorney is good at all things municipal. If you have a specialized attorney that focuses on this issue, I think you might get not necessarily different, but more refined
more refined.
results.
And, we don't know, maybe our solicitor, reviewed with someone.
Right, or maybe he is that guy. I don't know. I'm just saying.
But still having an independent third-party review for something this important, I think is prudent. I certainly wouldn't want everybody to take my word for it just because I sat here and rattled off a bunch of facts and figures.
That's why I'd say if like there was an independent committee that drafted a version and provided it to the supervisors, I think at that point, the supervisors would say, hey, this looks great, but let's get an independent third-party review on this.
I would
Had
say
to
for
go through.
sure, if we're gonna take input from,
Yeah, I would
An
say,
outside
I
group.
would
Mhm.
let's get the third party independent review first, regardless of what people come up with.
Right, I mean, otherwise, because you
Yeah, what you've just now wasted all that time.
Yes.
We kind of have a timeframe we're looking to, approve this, or get this, which is hopefully quick or quicker than sooner rather than later.
sooner rather
So
than later.
get the legal opinion on it first.
Right.
And if then, you want to get input, that's fine. But
And it could
Brass
certainly
tacks,
be
it's gotta be
a
legal.
two-track system. Here's what we have, review that, start a committee and go forward in another,
for round 3.
3.0 version.
Right. I would agree with that. So at this point, we want to not recommend as proposed, as drafted with the,
Say caveat, maybe without further legal review.
yeah, that's,
or at a bare minimum, speak with the solicitor as
Yes,
to
we got
where this came from. Like, was this just, a hodgepodge of other municipal
right.
laws
I
are
mean,
written,
is
or,
it-
has
is
this,
it
has this been
boilerplate
looked
or-
at?
Has it been tested in
Right.
court? Yeah.
I'm sure not much of it has.
Right, at this point, right?
But yeah, I mean, like I said, I think we have to have a certain amount of confidence in our solicitor. I think that'd be the first starting point would be to talk to the solicitor and see how much input he got on this before drafting. There's model ordinances out there that he might have.
So that's another thing. You keep handing me these easy ones. Out of all the ordinance I've reviewed, from townships and counties, nobody has the things that I pointed out in here as requirements. We're here, everybody else is over here. So the things we've got, we're unique, whether we're trailblazers or other kind of blazers, we're different.
Comments.
We came up with it. Everybody else used AI.
Right?
What are the new state statutes that were play into this? I mean, recently wasn't there? With regard to data center.
I don't know if there was a statute. The only thing I read there was an incentive program.
For data center. I mean, I thought there was two things that came through. I put the link.
There were two that were on the board. One, I think, was some kind of tracking program,
Yeah, but
and one was,
Well, no, that was just some person that did the tracking program. This was
right,
around the time of the last meeting when we first got, when 256 came out, went through the state and there was,
Yeah, there were two bills,
Two
they were
bills.
1250 and 1251. There were House bills. One was
right.
for the state to take a look at establishing a model ordinance. And the other one was reporting responsibilities for data centers, that they would report on an annual basis the environmental impacts of their facilities.
Yeah, I don't think legislatively anything was passed. The governor came out with some incentive program to recommend if you do extra X, Y, and Z, you'd get whatever priority review or,
Tax relief for whatever.
yeah. That was, yeah, I don't think there's been any finalized legislation.
There was another document that came out from the PUC giving the utilities guidelines for collecting additional fees for infrastructure improvements from the data centers. So that kind of replaces the one in here where we were mandating it. You know, again, that's a case where I think we're maybe a little bit ahead of where the state legislature is going, but I think slowly they're catching up to where we are. But if it's a state rule, then it's much more solid, on solid footing, enforceable. Yeah, that's the word I'm looking for. Yes.
Well, it would generally supersede a township regulation. If there was a state regulation.
All right. You know what? Let me open the floor. Do we have any public comment on this? If so, come to the podium and state your name and address. Okay. Dave?
He's not. Thank you.
Just questions. I appreciate all the work, John. Questions running in parallel. So we could, if we approved a second one, running in parallel with the professionals and getting all the from them with three, obviously, but special counsel on our side, kind of like doing another or and special counsel to give the people background that is designed to understand it as big at the core of such. I think there, I believe as a resident, running in parallel, I think it is to that. We're going to keep moving forward. I think citizens are straight up. Get input, better knowledge about everything that's what I'm bringing it together. And basically, what you do is you can work on it and change it to like need to work. Just say work through Fred and go down to China, and then they can be defined, and then the legalities behind it will be, you know, divvied up, divided, and pulled apart by the council. They give you actual, you know, what cases are false, you know, included for it or not. I just think if we could move in parallel, I think it's probably best, but I'm just one person.
I know, obviously, no job, no life. I think about this stuff all day long.
You're valuable at.
Better than doctors.
Valuable asset.
Oh, the other half of my life I spent in doctor's offices. Thinking of the two timelines, I don't know whether, you know, the concern with somebody coming in the door next week. Is it better to have two ordinances in place with possible need for corrections, that being challenged, versus having one recognizing, no, we're going to start a secondary legal review of that one before putting something in place formally. So that window between, you know, the version 3, let's put it that way. You know, if somebody comes in the meantime, what's the greater risk? Having two ordinances on the docket that are challengeable, or only having one with a legal review and process? That question I don't know.
I think that's where the special counsel, I think they would have the history of this and the knowledge of the things that I read the report yesterday, early this morning about the case based on I would say that he was actually one of the case that had developed. He was right. You know, why they're not great when people hard stuff like that. People down, say, why is it wrong? I'll have to actually get that stuff.
Yeah, like,
But yeah, there's so much information out there, it's hard to, go in and say, oh, this is hard, this is not, and go with 5 out of 6 or 5 out of 2, or 5 out of 10. I think this is what they fully focus. Yeah, probably have legal case, probably could, pull something out and say. But that would be definitely maybe, so that's what I'm doing. Still, yeah. Policy.
mhm.
That's fine. Appreciate you. Thank you.
Thanks,
Thank
Dave.
you.
And just for clarification, you wouldn't technically have two ordinances.
Right.
You have the ordinance that's already adopted that amended the code of the township, and this ordinance amends that code even further. Still just whatever's adopted or not adopted, not,
Right, but somebody could look at it and say, okay, fine, you amended it once, you amended it a second time. You know, that 256 is still going to sit out there, even if it's been replaced by 257. The history is that we've done this now twice.
What is the concern with that? I'm sorry.
So I'll play the devil's advocate. You know, this ordinance as it is gets passed next week.
Right.
No other changes. Next Thursday, a developer walks in with an application for building a data center. He's got a 25-acre lot. He looks at the ordinance and says, well, wait a minute. You're saying I need 35 acres, but there are no 35-acre lots in the township. How can you do that? See you in court. Gets to a court and the judge goes through this and says, you got some other things in here that are not good too. Whether it's throwing out the whole thing. Mr. Developer, you can go build whatever you want.
Well, I think that comes back to what we was talking about. There is a clause in there that prevents the whole thing being thrown out by 1, 2, 3, 4, 5, 6 issues, 20 issues. Whatever's left still stands. But I think you get to a point where when you start getting to 6, 7, 8 issues, it starts coloring the judge's perception of what is adequate and what's going above and beyond kind of thing.
Right. So it may not be 100% possible, 100% likely that he would throw it out, but even if it's 20% likely he would throw out the whole thing. It's
Well,
still.
I don't know that he could throw out the whole thing, but my point is it starts skewing his perception of the plaintiff versus the defendant kind of thing. And if you've been busted 6 times, is he going to be more likely to decide with the defendant or with you? And that's where my concern lies.
How would you guys like to proceed? To make it official, it sounds like we don't want to recommend adoption of this. What would it take for this to be adopted? What would you like to see happen? Let's get this nailed down so I have something to report. We want to have, I think first we need to talk to our solicitor. See what kind of teeth this thing has, what kind of due diligence he performed to put these things together. If he doesn't come up with an adequate response, then we move to go to a more professional level,
Third-party review.
a third-party review, a more,
Special counsel.
More
go ahead.
trying to come up with a specific skill set. for it.
Right, yeah.
Are you looking for a motion?
I think right now we're just spitballing for what we want to see. I don't know. Is there anyone else?
I would like to see a motion so we can move forward here. But I think we're on the right path here. We talked, we don't recommend until we hear from, we don't recommend, but we want to hear from our solicitor to see how much due diligence was performed on this. If he can't come up with a
Maybe how enforceable it is.
or, well, yeah, sure. Get his opinion on the whole thing. Obviously his opinion now is this is an ordinance that we want to adopt. We want to see, you know, if it actually does have the teeth or if we're overstepping. If he comes up with a good answer, then the supervisors have the ultimate.
They have the ultimate authority.
So if he
Yes.
comes up with a good answer at next week's meeting after hearing our report, supervisors can base it on that. If he comes up with a bad answer, they still have to make the decision to adopt or not. Our recommendation is, you know, have him dig in deeper, let us know how he came up with his information, how enforceable it is, or how liable it is. If he doesn't have a good answer to satisfy us or the supervisors, we recommend that we go to a more specified professional.
How about we include John's 6 bullet points at least as a starting point?
Well, yeah, that'll be handed to the supervisors through we'll include that in the minutes. 'Cause I'm not going to read that.
Wait a second. You're not going on vacation, are you, next week?
Yeah. So yeah, all your information, I think we're just going to incorporate into the minutes. Or do you guys review our minutes before your meeting? Okay. So yeah, so that would be incorporated into the minutes. They'll know our concerns. And hopefully, you know, the solicitor reads the minutes, or I'll contact Greg and let him know right away, you know, get him on board with the solicitor, get him on the horn with the solicitor to get some clarification on our concerns and go from there.
Do we want to do something making some of the other suggestions, even if the supervisors decide to move ahead with the way things are written? Would we want to incorporate something about providing a map of the flow pass and PE, PG seals?
Yeah, I mean, any recommendations that we want to include, or any standards that we want to include in the ordinance, I think that's worthy of note, and I'll report that, or it'll be in the minutes. I mean, so are we in agreement with Alex's concerns, or what he wants to put in the addition?
Yeah, I agree with Alex's concerns.
It's fine. Yes.
Yes. Steve, the only other question that's kind of lingering out there is the issue of how do you define building height? And I don't know if that's something to tackle here or whether we tackle that individually as a zoning.
I think it's cleaner to tackle individually.
Okay.
Because it's going to impact more than just this.
Right.
That may color how you actually craft that. Because there's a lot of existing buildings that would become non-conforming. So you might need to have some extra language in there to address existing structures or things.
Right.
So they don't need to come in for a variance every time Fresco wants to do something on their building.
Gotcha. All right. We're gonna make a motion.
I'll make a motion that we recommend to the supervisors that this draft not be approved. However, if it is approved, we'd like to see the issues I brought up incorporated into the approval of that draft. And then concurrently, we'd like to see the potential for a citizens advisory committee be created. I don't know, should that be a separate motion?
I think that's already in the works.
Okay,
That's actually gonna be on the agenda
For the third party independent review.
But yeah, we want to add something about the
solicitor review,
solicitor's review and
potential
possible.
third-party review.
Yeah. Okay, that's your motion.
Was that coherent enough?
Yeah, clean that up a little bit. Dave will explain it. All right, so there's the motion. Any second?
I'll second it.
All in favor?
Aye.
Aye. Opposed?
Opposed?
You didn't give me a chance to say.
Abstained? Or-
I don't know what it state. Aye, so.
All right, so you're the only opposition. So John is the opposition. All right, so motion carries. All right. So moving forward.
And I'm sure you're all aware, but just to reiterate, the ordinance as drafted will be on the Board of Supervisors agenda because of the advertised for that.
Right.
And they could adopt the ordinance as written
I'm sure they're going to.
next week. So just so no one's under misunderstanding that your recommendation puts a hold on everything.
Right. No, thank you. Yeah. Yeah, I mean, they may very likely adopt the way it's written and take our recommendation.
So can I make a counter motion?
I don't have my Robert's rule handbook in front of me, but yeah, you can make a counter motion, I guess.
So my motion is that we recommend to the Board of Supervisors that they halt proceedings, pull the existing proposed ordinance 257 back, perform an independent review prior to reissuing that ordinance for approval.
So I don't know how that falls in play with Robert's rules.
Yeah, because we've already,
Yeah.
yeah.
I don't know that it's different enough.
Okay.
From what was.
How about,
Can he rescind after we've already voted on
no, but maybe he
You're-
can
you're right.
modify his motion to say, should the ordinance not pass, you would recommend the following.
No.
it? Yeah,
I don't know how else it would. Otherwise, basically, it's A and B.
Yeah, it's sort of restating how you're denying it or not, or how you're not recommending it.
Right.
Yeah, it's sort of two things on the same issue. I don't think it's duly noted in the minutes. of
Yeah, it's
your
in the
concern
minutes, yes.
And your concern of why you voted the way you did.
So you want to rescind your motion or you just want us all to say we're not gonna second it?
If it's out of order to make such a motion, then I'll rescind the motion.
All right. Can we close this matter? I'm willing to close.
For the moment.
I make a motion, we close the matter.
I'll rescind that.
All right.
I'll second it. All right, so.
Next one's easier.
What's that?
Next one's easier.
I hope so.
Good.
All right, so the next thing on our agenda is an amendment to our residential accessory structures ordinance. So we've had a couple of instances of commercial properties with residences on site wanting to put up accessory buildings as residential accessory buildings, and they end up using them as commercial buildings. So is that accurate, Steve?
That's the concern, yes.
That's the concern. So apparently this amendment is drafted to handle that situation and basically throw covenants on if they want to put a residential structure.
Right. So if they did subsequently convert it, either they did it without approval, it would be a violation of the covenant, or they would come back to the township for approval and potentially have to do a land development plan because it's a commercial development. Right. Which was presumably all skipped because it was a residential building the first time around.
So is that the issue? Because I read this,
That's the issue.
I'll play dumb. I mean, I read this several times and I still didn't understand why we were doing this.
That's,
So if somebody, so what's the alternative? I guess maybe that's,
So let me give an example. Last guy we had in has the car shop up above my place.
Yes.
And he wanted to put that barn up strictly for personal use. So we had two other instances in the last couple of years where we had that same scenario and they end up using buildings for commercial use. So this guy, we actually got him to put a covenant, however that works. So we want to amend the ordinance to make sure that everybody puts a covenant on this project. So,
In other words-
so it remains residential. If they want to use that as commercial, they have to come back in and potentially go through land development.
I want to store
can we
my
s-
RV and my boat in this barn.
Right.
And then 6 months later, I'm storing bumpers and transmissions in this barn.
Right. So yeah, it didn't have to do land development because it was a residential accessory building.
So can we put something like that in here to make it more readable? The say, it says, it talks about, this is residential only, but it doesn't say what the alternative is. That's where I was stuck. Can we add a clause somewhere that says, if it's a commercial use, you need to do ...
No, that wouldn't be the appropriate place in the ordinance to have it. So if it's a commercial use, then it's not residential accessory building anymore. It's a commercial building. This section doesn't apply to it.
So what this is doing is limiting it to just a residential building and establishing a framework for how to enforce them.
Well, it's only in commercial
In the-
districts.
Right.
Too. It's not in residential districts. So I understand what you're saying. And I was thinking the same thing,
Right.
but I was going through it, but then, so the RA and all that's not, SR is not, it's only in the, the
Right. The industrial
PC,
commercial districts, right.
PC2, Planned Industrial DC and IS. So you building a residential, like on a RA lot, building a barn doesn't apply. It's if you're in a commercial, if you're a resident in a commercial district, you're a residential use in a commercial district,
Like me.
then if you go to build an accessory building, then as a residential use, you therefore would have to come back if you want to then use it as commercial. Doesn't prohibit you from using it as commercial. You'd have to come back and
If you use it as commercial, it's a violation as per the covenant.
Without further review.
Right. But I still think it would be helpful to put words in here that direct people on what they should do rather than just leave them hanging, creating a puzzle that, well, okay, what, like I said, I read it and I said, okay, well, what am I supposed to do now? Without having to hire a lawyer to read the ordinance to find out, you need to go over here to this section. Can't you just point somebody to say, if it's a non-residential use on a residential property, it needs to be filed as a commercial use? Is that too tough?
It's not a residential, well, if there's a residence and there's already a business there. Well, no,
I understand the concern, but you could say that for all kinds of sections of the zoning ordinance. So if you're a commercial building, you wouldn't be looking at the residential accessory section of the zoning ordinance. But there's no reason you'd be looking at this if you were a commercial building.
No, I'm thinking I'm a resident. I'm in one of these districts and I want to build a barn and raise chickens and sell eggs. And all of a sudden this is telling me I can't do this.
It doesn't say that. It just says you have to do a covenant to keep it an accessory building.
well, if you're selling the
No, say
eggs,
I
you're
want-
selling the eggs, that's
sell-
commercial.
That's
Right,
commercial.
right.
Selling it. Well, no. But if it falls under the ag,
Well,
it's still an ag use. You have,
Chicken or the egg, which came first?
you have
How about-
farm stand sales under the ag use, which is not commercial.
you can only sell 8 eggs.
Why'd you pick that?
Sell more than 8 eggs, then it's,
That's a whole nother explanation in another part of the ordinance.
Example of the guy with the auto parts sales on eBay was a good one. Because it's basically residential. He does have a commercial use on the property. He wanted to build this barn for the storage of his toys. But if that barn then got converted to storage of auto parts, that became part of the commercial use. And therefore, it was no longer residential use. So the covenants we asked him to put on the property prevented him from using that legally as anything other than personal storage.
That I understand, but I'm flipping it around. I'm saying I want to have a commercial business on my property.
Well, then you're
So-
gonna have to come through land development.
I have a suggestion. So in the ordinance 258, An ordinance of West Rock Hill Township Board of Supervisors amending chapter 450 of the West Rock Hill Township Code zoning by establishing additional regulations for residential accessory structures to prevent unlawful uses. What if we replaced unlawful with non-residential, to prevent non-residential uses?
You're changing the caption of the ordinance as opposed to the language of the ordinance.
Just replace unlawful with non-residential. How does that read? So basically it's saying that there's additional regulations for residential structures to prevent non-residential use. Or if commercials too, that's captures everything else, not just
Right.
commercial.
So daycare, anything else, yeah.
Well, if it was non-residential, it would be unlawful.
What is it?
If it was non-residential, it
To
would be
prove-
unlawful.
Right.
But
I mean,
that might make it
To
easier for
clarify
the
it from what
reader
John was
to
saying, kind of
understand
plain
what
speak, or
unlawful
I don't know.
means.
Yeah, I don't want to make an interpretation of what legally that should be, but I think if that's a concern of the town, of the plan commission, you can make that recommendation and the board could take it under consideration. It's a lot easier to change the title.
What's chapter 450? Like what is chapter?
That's the zoning ordinance.
The whole order.
The whole
Not-
order.
Not regarding to, not like commercial districts or
No.
It's a whole thing.
like resident, residential accessory structures to prevent unlawful uses in the commercial district.
Well,
Like
it-
residential structures in the commercial district to prevent unlawful uses.
it's even more complicated than that. I mean, the way this is structured, the title just talks that this is an ordinance to revise the zoning code, chapter 450. And if you go down to Article 1, you're changing section 450, 1604, use regulation, subsection H2, which is accessory residential structure. So that's down to specifics. That's what you're changing. So subsection H2 under 450, 604, which is residential accessory structure, will add this verbiage under that. So that's the only time you're going to see this verbiage is if you want to, you're proposing an accessory residential structure, you're going to see the regulations to have an accessory residential structure says if you happen to be in one of those commercial districts, you have to add a covenant.
Certain zoning district.
Otherwise, you're never going to, look at this section if you're proposing something else. Complicated, but that's
Okay.
the way they structure these things. But I do understand, looking at it out of context, why are we doing it and where do you go if that's not your issue? But in context, unless you're an accessory structure, you're not even going to look at that section of the ordinance.
I won't build a chicken farm.
Oh, you can build a farm, you just can't sell it.
Put your boat and cars in. The eggs. All right, so if that was the only concern and we got clarification on that, do we want to move to recommend?
I'll make a motion to recommend.
I'll second.
All in favor?
Aye.
Aye, opposed, motion carries. Thank you. That's what we had in new business, so I'll open the floor to public comment. Anyone has anything to say, come on up to the microphone and state your name and address. Seeing none, for a motion to adjourn.
That motion?
I'll second it.
All in favor? Aye. All right, meeting is adjourned. Thank you everyone for coming out.